So in this video, we're going to talk about when someone should use a no contest clause in their will or trust. So I'm Paul Rabelais. I'm an estate planning attorney. I help our clients get and keep their legal affairs in order. I think it was Dear Abby who said, if you really want to get to know someone, share an inheritance with them. I think sometimes some people show their true colors when they are dividing up a big pile of money with others. And so, and then in addition to that, sometimes people who are getting their legal affairs in order, they can foresee a family squabble. Maybe they know that there's some rivalry going on among the heirs or the children or the siblings that will inherit. Maybe someone has flat out told the person who's making the will or trust, I'm going to challenge it. So occasionally, I get that question. Somebody asked me, Paul, can we put a provision in our will or our trust that if somebody contests this, they get nothing? All right, so that leads us to a discussion about a no contest or in terrorem clause. And it usually says something like this in the will or in the living trust, whatever someone is using to leave their estate to their heirs or beneficiary. Usually it says something like this. I'm going to give you the short version. It usually says something like, if any person attempts to contest or oppose the validity of this instrument, then such person shall forfeit his or her share. Okay, so this is really a state law issue, and different states treat these things differently. My understanding is that there are 2 states out of the 50 where these no contest clause are just flat out unenforceable. Those states, Florida and Indiana. So I guess those states have determined, no, we want to give everybody their say in court. Everybody's due their day in court. So if somebody wants to contest something, they have the right to do that. The other states all in some form allow for these no contest clauses, but how they treat them can vary from state to state. Okay, so when there is a no contest clause, what kinds of actions typically trigger the person, to get nothing? Well, it's usually an attempt to set the will or trust aside, or to set a provision in a will or trust aside. Even though someone may have a no contest clause, there are certain actions that an heir might take that wouldn't trigger them forfeiting, everything they're due under the will. So things typically that don't trigger a forfeiture of the inheritance are things like, a lawsuit to construe the terms of a trust, or a lawsuit to determine whether a particular action by an executor or a trustee was consistent with the governing trust or will instrument. Or maybe even a suit to determine whether a particular challenge would violate the no contest clause. Maybe that one wouldn't trigger a forfeiture of the inheritance. And I'll tell you that it's pretty clear that these no contest clauses are typically construed, strictly and narrowly. So should you use a no contest clause? I think it's a state law issue. I think that at a minimum, what you might be doing if you use one is at a minimum, you're going to be getting that heir to really think twice about, issuing some challenge against your estate. But it is a state-specific issue, and so you might need to inquire, in your state to determine, what is and isn't enforceable as far as a no contest clause. But I think I know that, in the situations I've been in when someone passes away and then the potential heirs see that no contest clause in there, they're really a little gun shy towards, making any waves that might trigger them forfeiting the inheritance that they're entitled to. So good topic. Make sure you subscribe. Hit the red subscribe button and the notification bell so you don't miss anything. I'm going to keep educating the public on these, various estate planning issues, in the coming days, months, years ahead, and we'll see you next time.